So Gavin Newsom announced that he plans to use the scheme created in the Texas abortion law to destroy Second Amendment rights in California. So let's talk about this. But real quick before we jump into this video, if you think the state of California needs to stop infringing on our Second Amendment rights, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main supporters of the channel, which is Safe Life Defense. Safe Life Defense makes some of my favorite soft body armor out on the market. I actually like to keep one of them in my car just in case. So if you're interested, go ahead and click the link down in the details section, and thank you Safe Life Defense for supporting this channel. Also, I want you to know that this content is powered by the Firearms Policy Coalition. So head on over to joinfpc.org to help support the Second Amendment cause. Thank you again, Firearms Policy Coalition, for supporting this channel. So like I said in the intro, on December 11th, Gavin Newsom issued a press release stating his plans to weaponize the Texas abortion law in a way that will destroy our Second Amendment rights in the state of California. Now, I want to state right here and now that I will not be making any moral or political stance on abortion. That is not what this video is about. I may have my own personal and religious beliefs on the whole issue of morality and legality of abortion, but that is not what this video is for. This is about the procedural scheme created through the Texas law that is now being applied by the state of California against our Second Amendment rights. Now let me read to you the press release that was issued by Gavin Newsom. He stated, "I am outraged by yesterday's U.S. Supreme Court decision allowing Texas' ban on most abortion services to remain in place and largely endorsing Texas' scheme to insulate its law from the fundamental protections of Roe v. Wade. But if states can now shield their laws from review by federal courts that compare assault weapons to Swiss Army knives, then California will use that authority to protect people's lives, where Texas used it to put women in harm's way." He went on to state that I have directed my staff to work with the legislator and the attorney general on a bill that would create a right of action allowing private citizens to seek injunctive relief and statutory damages of at least $10,000 per violation, plus costs and attorney's fees, against anyone who manufactures, distributes, or sells an assault weapon or ghost gun kit or parts in the state of California. If the most efficient way to keep these devastating weapons off our streets is to add the threat of private lawsuits, we should do just that. So in this press release, Gavin Newsom stated that the state of California will be creating a similar piece of legislation like Texas did with abortion. But in this case, the statute will target anyone who manufactures, distributes, or sells an assault weapon, ghost gun kit, or parts in the state of California. Now you may be asking yourself at this point, what does that mean? Well, they will be allowing any private citizen, regardless of who they are, to sue a gun store, a gun manufacturer, or person who engages in selling these types of items. Ultimately, the goal is to chill the exercise of Second Amendment rights in the state of California through the threat of gun stores, makers, or people being sued into oblivion. Now, how did we get here? Well, as you are likely aware, Roe v. Wade in 1973 held there is a constitutional right to abortion. Whether you agree with that is an issue for a different video. The Roe decision was based on a trimester framework. In the first trimester, a state couldn't do much to restrict abortions. In the second trimester, they could do a little bit more. And by the third trimester, the state would have much more authority to implement restrictions. After Roe came Planned Parenthood v. Casey. In that case, the court threw out the whole trimester framework of Roe, but instead said viability is the issue, and prior to viability, a state cannot place an undue burden on abortions. After the point of viability, a state could put in place restrictions. Well, now you have Texas, who came after the fact of these cases and has passed SB 8. SB 8 is the Texas abortion law that's in question, and it prohibits an abortion if a fetal heartbeat is present, which is at about 6 weeks. This law is different from other laws because it is not enforced by the state or Texas or any of its executives, but rather it allows individuals to sue any other individual who performs or knowingly aids and abets an abortion. So essentially a medical provider, a family member, a friend, or really anyone who aids and abets an abortion can be sued. This means that the class of plaintiffs that could bring a lawsuit is very large and unknown, and also the class of defendants that could be sued under this law is also very large and unknown as well. In these Texas lawsuits, an individual can seek an injunction against the performance of an abortion and also seek a minimum of $10,000 in damages against the violators, and also they can seek the repayment of attorney's fees and costs from them having to bring this lawsuit against these defendants. Essentially, the law's goal is to have a chilling effect on the performance of abortions because you could have thousands of people file lawsuits for just one specific incident. This law is the epitome of death by 1,000 cuts. SB 8 went into effect in Texas on September 1st, but prior to that, those opposing the law, like abortion clinics, Planned Parenthood, etc., filed a pre-enforcement challenge in federal court. Now here is where things become relevant for the Second Amendment rights and what Newsom is planning to do. Pre-enforcement challenges seek to stop the enforcement of a law before it takes effect and before people suffer some sort of harm. For example, someone could seek a pre-enforcement injunction against the state of California and the Attorney General when they pass a new magazine law. However, the issue is SB 8 was designed in a way that specifically frustrates federal pre-enforcement challenges. SB 8 shielded Texas and officials from pre-enforcement lawsuits, since the statute allows only individuals to bring a lawsuit, not the state or its officials. The enforcement mechanism of the law was designed in order to make it harder, if not impossible, to have a law like this struck down. This is because courts don't actually strike down laws. What they do is they put in place injunctions against the enforcement of a law. So for a hypothetical, a court could enjoin the California Attorney General from enforcing a ban on magazines. The result of that injunction is essentially the nullification of that law. If the state is barred from enforcing a law, then the law really has no effect. Well, with SB 8 in this scheme, however, you can't get this umbrella injunction against the state and an attorney general since they aren't the ones enforcing the law. Instead, you can get an injunction against the individual person suing you, but then someone else could pop up and sue you for the same thing. And then after that, and you get that injunction, someone else sues you and you get an injunction against them. Well, then someone else pops up and they sue you and you have to get an injunction against them, and it goes on and on. Now, the SB 8 issue made its way up to the Supreme Court in the Whole Women's Health v. Jackson case. And despite what you hear, this issue in this case was not necessarily the constitutionality of abortion or trying to reverse Roe v. Wade, but instead the issue really was whether a lawsuit and scheme like this created by SB 8 is permissible. If you're interested, the Dobbs case, recently heard by the Supreme Court on December 1st, is in fact a straight-up constitutional challenge to abortion and is seeking to overturn Roe and Casey. So that's a completely different case from this issue here. This SB 8 case, however, really dealt with a prior Supreme Court case called Ex parte Young. Ex parte Young deals with the 11th Amendment, which says that private citizens cannot sue the state or other officials because they have sovereign immunity. However, a citizen can sue a state or its officials if they are violating civil rights. These are often known as Section 1983 lawsuits. Under Ex parte Young, if an executive branch official is violating your constitutional rights or is threatening to, then you can seek a prospective injunction against them, i.e. a pre-enforcement challenge. But Ex parte Young says that you cannot sue judges and potentially clerks in the same way. Well, since SB 8 does not involve the enforcement through the state or its officials, then you cannot seek an injunction against them. And also the recent Supreme Court ruling in SB 8 just said that under Ex parte Young, you cannot seek an injunction against state judges or clerks who are part of the SB 8 lawsuits when they are filed. Also, the way the law is structured keeps these lawsuits in state courts instead of federal courts. This further insulates these types of lawsuits from federal court review. And with this structure of SB 8 recently being upheld by the Supreme Court, Newsom is planning to weaponize it against the Second Amendment. This was a significant concern going into the Supreme Court arguments on SB 8, and FBC even wrote an amicus brief on this. In it, they argued that this could easily be weaponized by states like California and New York against other rights like your Second Amendment rights and also your First Amendment rights. And now with this decision in upholding SB 8's scheme, you see California weaponizing that same scheme, but just against Second Amendment rights. So if you're in the state of California, you should fully expect that the state will pass an SB 8-like statute, but instead it will focus its attack on Second Amendment rights. And it will do this by allowing individuals to pursue lawsuits against any gun maker, gun store, or anyone really who sells 80% lower kits, so-called ghost guns, so-called assault weapons, or any parts that could be used to build those items. And unlike with other laws California has put in place in the past, we cannot file a federal court case seeking an injunction. There will be no opportunity for a federal judge like St. Benitez to hear one of these cases and issue an injunction. Instead, these will have to be litigated on a case-by-case basis in California state courts. And that is the scary thing about this whole scheme. It's the law protects the state of California and their attacks on our Second Amendment rights. It puts this kind of umbrella protection on it and keeps these types of issues in state courts and also prevents any type of pre-enforcement injunction. This whole issue is likely going to become a giant mess, and it's likely going to unravel next year. So we will be keeping our eyes on this and see what happens. But hopefully that helps shine some light on this issue, especially for those of you who are asking me questions about this, sending me articles, sending me the press release. I appreciate that. I was aware of it, and hopefully this helped shine some light and gave you guys some information to work with. So if you guys have any questions, go ahead and comment down below, and I'll try to answer to the best of my ability. Also, if you like this video and like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Algor's rhythm. It adds fuel to his jet, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. So thank you so much to everybody who's liked, commented, subscribed, who's hit the notification bell, and who has shared these videos. You guys are directly impacting these videos, helping this channel to grow and reach more people than I could have ever thought. Especially thank you to everybody who shares these videos. You guys are directly impacting the YouTube analytics, especially when YouTube does not want to push these videos heavily. So thank you so much for that. Also, if you don't have a comment in mind, just comment down below as your comment to fuel the algorithm, and that also really does help the channel. So as always, thank you all for watching. Don't forget to like and subscribe, and don't forget this nation is built by armed scholars. This nation will be maintained by armed scholars.